Hi, I'm Darcel Lobo, and I own DAL Law Firm in Normandy Park, and here today to talk to you about the probate process. Now, probate is just the administration of one's estate according to their will or according to state law if they don't have a will. Now, to understand your will and the role of your will, it is just a set of instructions of what you want to have happen, but it does not empower anyone to make those things happen. That's where probate comes in. In the probate process, your will is filed with the court clerk, and then the court oversees the administration of your will through the probate process. So whoever you have appointed as your executor, whoever you listed as your heirs, the court will oversee and ensure that your wishes in your will are fulfilled through the probate process. Now, when probate is opened, if you had a will, then there'd be letters testamentary that are issued, and without a will, there'd be letters of administration. And these are a court order that show whoever you have appointed as the executor in your will has the power to then liquidate your assets and make the distributions according to your will. Upon probate opening, there's going to be a notice that gets sent out to all of your heirs, notifying them that probate was open and your executor was appointed to administer your estate, again according to your will or without a will according to state law. The executor is in charge of identifying all the assets and all the debts of the estate, and they do so by reviewing your records, your mail, going through personal items to figure out what assets did you own and what debts did you have, what liabilities did you have. Now, during the probate process, there is a certain period of time for creditors to make claims. And if they want to be paid on the debts that are owed to them, they are required to file a claim in the probate process. Now, this window is a 4-month window in Washington State. Once we open the probate, we have to give notice to any known creditors, and then we also issue a publication in a local newspaper notifying any unknown creditors to let them know about the decedent's passing and their ability to make a claim if they wish to recover any funds from the estate. Now, once your executor has liquidated all the assets, so selling real estate, closing out bank accounts, accessing investments, identifying all of your personal property, once they've liquidated all those items, then the next step would be for them to pay the debt. So whatever debts the decedent had, whatever probate expenses they have incurred, so reimbursement for funeral costs, probate attorney's fees, court costs, things like that, would all be paid first, along with, again, any debts that there were, before there's any distributions that are made to any heirs of the estate. In addition, the executor will have to make sure that any tax returns that were not filed for the decedent are filed, and the estate may need its own tax return file, which the executor will have to take care of as well for the decedent. Now, in general, probate will take usually around 9 to 12 months. It could be shorter, maybe as short as 5 or 6 months, but that's pretty rare. In my experience, 9 to 12 months is more the norm. If there are multiple pieces of property, if there's multiple heirs, if there's any disputes, then it of course can take quite a bit longer, and some probates have been known to go on for a few years because of this. But generally speaking, I think around 1 year is a good expectation, a realistic expectation, when things are pretty straightforward and there aren't any disputes among the heirs and there aren't multiple pieces of real property that have to be sold. So if you have any questions about the probate process, if a loved one has passed away and you're not sure if probate is needed, or if you want to better understand how you can assist your heirs by having your estate plan in place, give our office a call. Our number is 206-408-8158, or you can visit us online at dallawfirm.com, which is DALLAWFIRM.com. Thank you.